Okay, guys, welcome back to our YouTube channel. Welcome back to Mr. Sanchez's YouTube channel, actually. We're going to go over the required SCOTUS cases. My name is Lorena Maria Andrade, and this is Jade Alexandra Vela. We're going to start off with Marbury versus Madison from 1803.
Okay, so we're going to start off with the facts. The controversy arose during a presidential transition when President John Adams appointed Federalist Party members to judgeships. Secretary of State John Marshall prepared commissions, but 17 appointees, including William Marby, did not receive official notice. This led with the holding answering the constitutional question with the Congress established with the judicial review and its principles, which gives the power to pass laws and declare laws unconstitutionally, with the reasoning of Marshall's Supreme Court ruled that appointed judges with signed commissions can sue if denied jobs, but ruled the law contradicting Article 3 of the Constitution, canceling Marbury's claim and implementing judicial review. The case had the decision of the court agreed with Marbury and ended up establishing the principle of judicial review, which is the power to judge whether the actions of the legislative and executive branches of government are lawful, and has been granted to the courts. This case had no dissenting opinion.
Now we're going to get into the case of McCullough versus Maryland from 1819. The facts of the case are that the state of Maryland questioned the legality and the constitutionality of creating a federal bank. Maryland recognized that the state has authority over the banks in their area and that the Constitution does not explicitly give the power to the federal government to create a federal bank. Maryland passed a law stating that every bank within its borders that is not incorporated by Maryland has to pay a fine. McCullough refused to pay, and it went to the Supreme Court. The Supreme Court held that the federal government could implement a bank and that Maryland could not tax instruments of the federal government. This is because, although the power wasn't explicitly stated, there were many terms that provided the basis for creating a bank. The Supreme Court argued that it was constitutional under the necessary and proper clause as well. They ruled with McCullough, Maryland could not tax instruments of the federal bank, and the Constitution did in fact grant the federal government the powers of the purse and by extension the right to create banks. It was a unanimous decision to rule with McCullough.
Okay, next we have the Schneck versus U.S. 1919 case. We're going to start off with the facts. The 1917 Sedition and Espionage Acts prohibited publications criticizing the government, advocating treason, or inciting military disloyal behavior. Charles Schneck, the secretary of the Socialist Party, was convicted for printing anti-draft leaflets to dissuade Philadelphia area draftees from complying with the draft, despite appealing the verdict. From the holding, they ruled that the Espionage Act doesn't interfere with the First Amendment. That led in with the reasoning that the Supreme Court upheld the government's right to convict citizens for certain speech, balancing free expression demands with protecting society, with the clear and present danger test determined the constitutionality of expressions during wartime. This led the case to have the decision going for no for U.S., and that because the First Amendment could be limited if the speech causes danger. This case also had no dissenting opinion.
So now we have Brown versus the Board of Education from 1954. Basically, it was legal for states to segregate public schools on the basis of race. The Supreme Court held that the state-sanctioned segregation of public schools was a violation of the 14th Amendment, which was supposed to provide equal opportunity and equal liberty. The segregation of public schools on the basis of race creates inequalities between the races and causes inferiority complexes, which affects the children in the schools. The Supreme Court ruled with Brown segregation in public schools was unconstitutional, and Judge Harlan argued that the Constitution saw no color and made no distinction among the people, and therefore the segregation was not unconstitutional. So basically what that means is that Judge Harlan argued that the Constitution, since it did not explicitly say that we're providing equal opportunity to people of color or to any specific race, that there was no distinction between them, and then it was not unconstitutional because it wasn't explicitly stated.
Next, we have Baker versus Carr from 1962 case. The facts of Tennessee's 1901 law required redistricting every 10 years, but the legislature failed to do so. This led to rural areas having lower constituent-to-lawmaker ratios, resulting in minority rule and conflicting with democratic principles in 1959. Litigants sued the Secretary of State, claiming population variations violated the 14th Amendment. The case had the holding of, yes, the Supreme Court can render judgment on the constitutionality of legislative districts. If there is unfair representation for citizens in the legislative district, it is unconstitutional and can be looked at by the courts. They had a reasoning of, the court ruled that Tennessee outdated and uneven populated legislative districts violate the Equal Protection Clause of the 14th Amendment. It established principle, jurisdiction, and six criteria for determining political questions. Chief Justice Earl Warren praised Baker versus Carr for establishing the one person, one vote principle that had Democratic participation go up. The case had a decision of deciding with Baker. It did end up violating the Equal Protection Clause, making it okay for the courts to have district become more equal to make it more fair. The case had a dissenting opinion of where they argued that they violated the separation of powers between legislators and the courts. Going into redistricting was a political issue and not an issue for the courts.
Next, we have Engel versus Vitale from 1962. The facts of the case are that the Constitution upheld the separation of church and state, yet school sponsored prayers and Bible readings were still ongoing. The Supreme Court held that school sanctioned religious activities were against the separation of church and state. And basically, what the separation of church and state means is that the federal government cannot implement any one religion as an official religion in order to protect the freedom of religion. So the reasoning for this was that school-sanctioned religious activities were an endorsement of a specific religion, and the Establishment Clause in the First Amendment protects against the state or federal endorsement of any one religion. The Supreme Court ruled with Engel, and the government had no reason or standing to draft religious programs or prayers. After school hours, religious groups were able to meet. The dissenting opinions were from Justice Stewart. They argued that the Establishment Clause only prohibits state-sponsored religion, not for any form of government to be prohibited.
Now we have the Gideon versus Wainwright 1963 case. For the facts, there was a guy named Clarence Earl Gideon. He was a drifter. He was convicted for stealing in Florida and was convicted without a lawyer. The Supreme Court ruled that the states must provide defense attorneys to indigent defendants regardless of the severity of the crime, following the 14th Amendment's Due Process Clause. This case had the holding of having a right to legal counseling for criminal defendants in court, so the state prosecuting of the criminal defendant without counsel does violate the Sixth Amendment. They had reason of the court ruled that the defendants should have equal trial chances and that appointing an attorney for indigent individuals is constitutional, arguing that the 1942 Betts versus Brady case contradicted that. The case ended up deciding with Gideon. The Supreme Court ruled that we had the guaranteed right to legal counsel in court. There was no dissenting opinion. The court ended up voting unanimously.
Tinker versus Des Moines from 1969. During the Vietnam War, morale was at an all-time low. Citizens and soldiers wanted to withdraw from the war. Students in Des Moines, Iowa, went to school wearing black armbands to protest the war peacefully. They were later told that it violates school policy and that they would be expelled if they continued to do so. An important note about this is that their protest was not disruptive and it was very peaceful. So the Supreme Court held that the freedom of speech is protected under the First Amendment. Teachers and students retain their constitutional rights during school hours. The reason was that wearing black armbands to school was a peaceful protest and it did not disrupt the school day or cause any harm to any students or teachers. This decision that they made was ruling with the students. Neither teachers nor students shed their constitutional rights at the schoolhouse gate, and that is a quote from one of the justices. Their dissenting opinions were from two justices that opposed the ruling. The First Amendment does not grant the right to express any opinion at any time. Basically, their dissenting opinion was that there is a time and a place for expressing their opinions.
Okay, now we have the New York Times versus U.S. 1969 case. With the facts, we have Daniel Ellsberg, a Pentagon analyst, released the Pentagon Papers in 1971, revealing government deception and questioning the government's credibility. President Nixon sued the Times for censorship, but the Supreme Court ruled in favor, saying that censorship does not justify an advance. Ellsberg was later indicted under the 1917 Espionage Act. The Supreme Court held that the executive branch can block out for this specific case, but they can't because the government doesn't have proper justification. They had a reason of the court issued a per curiam opinion, which is basically just a court opinion issued in the name of the court rather than the specific judges, overruling the lower court's injunction and preventing the executive branch from stopping the printing, relying on previous cases' reasoning. They had a decision where the president's attempt to stop the publishing of the Pentagon's papers violated the First Amendment. The freedom of the press, New York Times would be able to go along with publishing because the government could not have proper justification for prior restraint. The case had a dissenting opinion where the government should have the ability to press prior restraint on the press, especially when national security was at risk, which what they thought was going out for this case.
Our next case is from 1972, Wisconsin versus Yoder. Amish children were required to attend school, although it was against their religion, which limits formal education. The Supreme Court held that the state of Wisconsin could not enforce or require Amish students to continue their education after the eighth grade. The reason for this was that a state law requiring attendance to school past the eighth grade violates the parents' rights to direct the religious upbringing of their children. The Supreme Court ruled with the Amish community, schools could not require attendance past the eighth grade because it infringes on their religious freedoms, which are protected in the First Amendment. There was a unanimous decision to uphold the freedom of religion in the First Amendment for the Amish community.
Okay, now we have the Shaw versus Reno 1993 case. The facts. In 1990, North Carolina submitted its congressional district map to the Federal Justice Department for review, following the 1965 Voting Rights Act. The court ruled that using a race as a basis for creating legislative districts was permissible for fairness. However, only one district was a majority-minority district, so they ended up reshaping districts and making weird ones to benefit them. The Supreme Court held, yes, a congressional district designed for the purpose of assuring a majority black population does violate the 14th Amendment Equal Protection Clause, with reasoning of the court ruled in favor of Shaw, stating that race alone could explain the irregular district shape and its lack of other characteristics violating the 14th Amendment and the colorblind ideal of United States law. This had the decision with the court ruled with Shaw at 5-4. It is unlawful to design district for assuring specific races and minorities. It was obvious that North Carolina had a gerrymandered off race. This court also had a dissenting opinion of that they believed that what North Carolina did wasn't going against the 14th Amendment and they should be allowed to redistrict to better represent a minority group.
Okay, now we have the United States versus Lopez from 1995. Alfonso Lopez was found carrying a gun inside a school and was arrested and charged by the state of Texas with firearm possession on a school premises. Later, the charges were dropped by the state, and instead, Lopez was charged with a federal crime under the Gun Free School Zones Act of 1990. This case went to the Supreme Court, and the Supreme Court held that the Congress had no jurisdiction to involve itself in Lopez's crime, as it did not fall under the Commerce Clause. The reason for this was that crime was not related to economic activity nor interstate commerce. The court ruled that Congress had overstepped under the Commerce Clause. This decision was that Lopez having a gun inside a school zone was outside of the congressional power, and that the Gun Free School Zone Act was an overreach. The dissenting opinions came from Justice Stevens, Breyer, Souter, and Ginsburg, which held that Congress had the power under the Commerce Clause to prohibit gun possession anywhere, not just inside schools.
Okay, we're almost done here. We have McDonald's versus Chicago 2010 case. The facts. Chicago and Oak Park citizens challenged gun registration through policies similar to those in Washington. Chicago required gun owners to register but refused handgun registration, creating a ban. The plaintiff, Otis McDonald, argued that the Second Amendment should have prevented this vulnerability. The Supreme Court held the Second Amendment does apply to the states through the 14th Amendment and cannot ban citizen ownership of handguns. The reasoning with the court applied the Second Amendment to states through the 14th Amendment's Due Process Clause, arguing that individual self-defense is central to the Second Amendment. The court also highlighted the historical context of the 14th Amendment and the right to self-defense. They had a decision of the court ruled with McDonald's 5-4. The Second Amendment is applied to the states through the 14th Amendment and they cannot deny ownership of handguns. The ban in Chicago would have left McDonald's without self-defense. The dissenting opinion was they disagreed with the statement of the Second Amendment not applying to the state through the 14th Amendment.
Okay, we're going to wrap this up with Citizens United versus the Federal Election Commission in 2010. Citizens United sought to prevent the Federal Election Commission from being able to apply the BCRA, which is the Bipartisan Campaign Reform Act, to their movie on Hillary R. Clinton, which had political opinions as to whether or not she would make a good president. BCRA is a form of regulating corporate involvement in politics and campaign spending. So basically, Citizens United made a movie on Hillary Clinton, and they sought to move that the Federal Election Commission could not infringe on their making of that movie. The Supreme Court held that corporate and unions may not give money directly to campaigns, but the government cannot keep them from spending their money to support or denounce any particular candidate by way of ads or other forms. The reason for this was that the rights expressed in the First Amendment apply to every citizen regardless of their corporate identity. The government cannot infringe upon that right. Their decision was that ultimately the First Amendment prevents the limitation of political spending in corporations as it is a form of free speech. The dissenting opinion was from Justice Stevens that the American people have a recognized need to prevent the corporations from undermining the government. All right, that concludes our 14 required SCOTUS cases presentation. Thank you guys for tuning in.
Make sure you hit that like and subscribe button, guys.